Lesbian, gay, bisexual and transgender rights in the United States have evolved in recent decades. However, LGBT Americans may still face some legal and many social challenges not experienced by non-LGBT residents, particularly in states with large conservative populations, such as in the Deep South, in rural areas, and in some Native American tribal nations. Many LGBT rights in the United States have been established by the United States Supreme Court. In 5 landmark rulings between the years 1996 and 2020, the Supreme Court invalidated a state law banning protected class recognition based upon homosexuality, struck down sodomy laws nationwide, struck down Section 3 of the Defense of Marriage Act, made same-sex marriage legal nationwide, and prohibited employment discrimination against gay and transgender employees. LGBT-related anti-discrimination law regarding housing and private and public services varies by state, leaving residents of some states unprotected. 23 states plus Washington, D.C., Guam, and Puerto Rico outlaw discrimination based on sexual orientation, and 22 states plus Washington, D.C. outlaw discrimination based on gender identity or expression. The Equality Act, which is currently proposed in the United States Congress, would outlaw discrimination based on sexual orientation and gender identity nationwide. Family law also varies by state. Adoption of children by same-sex married couples is legal nationwide since June 2015 following the Supreme Court's decision in Obergefell v. Hodges. Policies regarding adoption vary greatly between jurisdictions. Some states allow adoption by all couples, while others ban all unmarried couples from adoption. Hate crimes based on sexual orientation or gender identity are punishable by federal law under the Matthew Shepard and James Byrd, Jr. Hate Crimes Prevention Act of 2009. But many states lack state-level hate crime laws that cover sexual orientation and/or gender identity. LGBT people of color face the highest rates of discrimination and hate crimes, especially trans women of color. Civil rights for LGBT people in the United States are advocated by a variety of organizations at all levels and concentrations of political and legal life, including the Human Rights Campaign, Lambda Legal, GLBTQ Legal Advocates and Defenders, American Civil Liberties Union, the National Center for Transgender Equality, and the National Center for Lesbian Rights. On June 26, 2003, the Supreme Court ruled in Lawrence v. Texas that intimate consensual sexual conduct is part of the liberty protected by substantive due process under the 14th Amendment. The majority opinion, written by Justice Anthony Kennedy, explicitly overruled Bowers v. Hardwick, a 1986 decision that found sodomy laws to be constitutional. Despite this ruling, some states have not repealed their sodomy laws and local law enforcement officers have used these statutes to harass or arrest gay people. Prior to the 2003 Supreme Court ruling in Lawrence v. Texas, same-sex sexual activity was illegal in 14 U.S. states, Puerto Rico, and the U.S. military. By that time, 29 states, the District of Columbia, and 5 territories had repealed their state's sodomy laws by legislative action. After the repeal of Don't Ask, Don't Tell in 2011, the U.S. Congress repealed sodomy laws in the U.S. military in 2014. 12 states have had state Supreme Court or state appeals courts rule that their state sodomy laws were unconstitutional. Georgia, Louisiana, Massachusetts, and Minnesota have all had their state sodomy laws struck down by the courts. But the legislatures have not repealed those laws. On April 18, 2013, the governor of Montana signed a bill repealing that state's sodomy law. It had previously been nullified by the Montana Supreme Court. On April 23, 2014, the governor of Virginia signed a bill repealing that state's sodomy law. On October 1, 2020, a bill repealing Maryland's sodomy law went into effect without the governor's signature. 14 states either have not yet formally repealed their laws against sexual activity among consenting adults or have not revised them to accurately reflect their true scope in the aftermath of Lawrence v. Texas. Often, the sodomy law was drafted to also encompass other forms of sexual conduct such as bestiality. And no attempt has subsequently succeeded in separating them. 11 states' statutes purport to ban all forms of sodomy, some including oral intercourse, regardless of the participants' genders. Florida, Georgia, Idaho, Louisiana, Massachusetts, Michigan, Minnesota, Mississippi, North Carolina, Oklahoma and South Carolina. 3 states specifically target their statutes at same-sex relations only: Kansas, Kentucky, and Texas. The age of consent in each jurisdiction varies, but in most jurisdictions it is equal to the age of consent for heterosexual sex. The exception to this is Texas, whose statute books still hold an OUTD.